Good evening. This is Laws 12067 Environmental Law. This is week 2 in term 3, 2015. John Milburn. We have a lot to cover tonight, so I'll attempt to move through that fairly quickly. And it may be that there are some questions that you wish to ask, so please feel free to do so as we progress, or use the chat facility as usual. This year I hope to have a few guest speakers. I'm speaking with the Environmental Defender's Office. Very appreciative to Liz Chevelle for making an initial contact there. And Sean Ryan, Principal Solicitor with the EDO, has agreed to speak with us. One of your colleagues, Andrew McGoffin, is a town planning consultant, and I'm going to avail myself of his expertise in terms of providing some information about the IDAS process, and I'm looking forward to that. And Phil Jeston is going to make a further guest spot, probably the first lecture after the new year, in terms of an update in relation to environmental impact statements. If you have any other individuals that you think can add to the course by providing a guest spot, please let me know, and we're very happy to speak with them and incorporate that into the material. This week I have, as I said, a lot to cover. I'm very happy with the involvement of students generally through UCREW. Thank you very much for doing that. Please keep it going. I like the discussions that we're having, and it's all very excellent. All right, so just a few basic things. Those of you that have studied with me before, you know, I guess, the way that I like to work, and that the way that I like to have your work presented. In general terms, can I just say, work towards a goal. Think about what you want to achieve and work backwards. The reason I'm saying that is I'm acutely aware that, as excellent as this book is, that is a huge text, 900 pages, and some of it's fairly straightforward, but a lot of it's not easy. So I don't want you to be discouraged and find that it's just too difficult to get through that task. So please try and think about what you want to achieve and then work backwards, and don't be overly daunted by the material that you have in front of you. It's voluminous, I appreciate that, but it's all good fun. So when it comes to writing the material that you're going to write, just be careful to write persuasively. Don't necessarily think there's a right or wrong answer. I'm much more interested in the argument and your ability to identify the important principles, rather than necessarily having a right or a wrong answer. So keep your writing simple. Do watch out for the word limits. I'm pretty keen to ensure that you keep to or near enough to the word limits. You can use a variety of different formats to display your work, and I think sometimes that's an excellent way to do it, using graphs or graphics or flowcharts or whatever it might be is always a great way to go. All right, so if there's any questions, please feel free to interrupt, unmute your microphone, and use the chat facility if you prefer. But it would be very nice to hear from you. Now, the study of environmental law, it's quite new, as we talked about last week. It incorporates contents from a whole different range of different practices. You would have seen it already: constitutional law, contract law, criminal law, torts law. It's got a lot of material, even though it's a new discipline, a lot of material which comes from different sources. And of course, administrative law is a big part of environmental law through the process of merits appeals in particular. All right, well, I'm not going to go through the chapters of the book. You would have seen, no doubt, the video sessions that I have where I, if you like, summarize what is to me the important content of the chapters of the text, and provide a little commentary to go with that. So I'm not going to repeat that in these sessions, but I do urge you to have a look at those pre-recorded sessions to camera in relation to my commentary on the book. The reason I do that is because I'm aware that there's a lot of material, as I said, and you might be interested to know what I think is the most important part, but bear in mind, of course, that it's ultimately up to you to decide what is the most important part of the reading material. You may disagree with what I emphasise and feel that there are other aspects of the text that should be emphasised. Now, if you haven't already done so, I urge you to have a look at the key legislation. At the Commonwealth level, of course, it's the Environment Protection and Biodiversity Conservation Act, or EPBCA, 1999. Also have a look at the regulations from 2000, the EPBCA regulations. Or forget the A, just go with the regulations. Also have a look at the Commonwealth of Australia Constitution, especially sections 51, the powers, 52, Commonwealth places, section 109, the supremacy of Commonwealth, we're inconsistent with state law. And Liz Cheval raised an excellent point in relation to section 100 in UCRU. I've provided a response to that. Please feel free to add your commentary to it, because Liz has raised an issue that really isn't covered in Bates. And I must confess that when I first saw that question, the first thing I did was dive for Bates to see if there was an answer there. Now, that is actually contrary to my normal practice. The normal practice that I adopt is to go straight to the primary source, the legislation, and if not the case law. So I went to the secondary source first. It wasn't there, so I went back to the primary source and used the note-up facility to find the decision of Arnold, the High Court case from, I think, 5 years ago, 2010. I trust that you all know how to use the note-up facility in Austlii. If you don't, then please do so. In fact, I'll just see if I can quickly show you that, just as a refresher in case anyone has forgotten how to use that excellent facility. I'm just going to share the screen for a moment. And if this is too basic, I apologise, but it'll be quick. You should now see my other screen. And that's the case. Just give us a thumbs up if that's the case. Yes, you can see the other screen. All right, very good. So if we go to Commonwealth, a bit slow tonight, you'll see legislation, consolidated acts, where is it? After the Commonwealth of Australia, there it is, Constitution Act. Section 100 was the one that Liz raised, and quite a simple section, but the note-up facility here is very important because that will give you the relevant case law applicable to the section, and there it is, Arnold. That's the one that I looked at in providing some commentary in relation to the issue that Liz raised. And I think I looked at and said that one of the great advantages, of course, is you can just skip from one reference to another for section 100. So it makes it pretty easy to do some legal research and provide some commentary. And I think from memory, I made reference to something down here to do with section 100. Anyway, I won't wander on too much, so I'll stop the share. Are there any questions to do with NoteUp or the way in which I used it and my preference for using primary sources of legislation as opposed to necessarily going to the secondary sources first up? No questions? All good? All right, I'll just go on gallery view, see who we've got. We've got a few more people here. Nice to see you. Don't feel too shy about leaving the camera on. It's always nice to see your fellow students and feel more involved in the class. So Jane has joined us, Cheryl, Jessica, that's great. Thank you. All right, so if there's any issues or questions as we go, please ask. All right, so at a Commonwealth level, we have the EPBCA. I trust that you've looked at that already. Also have a look at the Commonwealth Criminal Code. Just briefly, you can get really bogged down in that one. The Administrative Decisions Judicial Review Act of 1997 is another piece of Commonwealth legislation that you should consider looking at. In Queensland, of course, the key piece of legislation is the Sustainable Planning Act. And Jessica said, right, no camera, that's fine, Jess. The Sustainable Planning Act 2009, which is under review at the moment. But in addition to that, don't forget the Environmental Protection Act 94, Nature Conservation Act 92, and the State Development and Public Works Organisation Act of 1971. That last act deals with issues to do with Coordinator General. We'll talk about that a bit more when we talk about the interaction between the Commonwealth and the states in terms of bilateral agreements, etc. Okay, I know I'm moving pretty quickly, but we have a lot to cover. So if you need to stop me to ask a question, please do so. In the text and the materials that I've presented, you would have seen the different courts that apply for, or that are relevant to the practice of environmental law. In Queensland, unsurprisingly, the most important court is the Planning and Environment Court. So for environmental law, we have our very own court, and I think that's just wonderful. You don't have that for other areas of practice in many instances. So we have our own court, the Planning and Environment Court. That's probably the first place that you should look to in terms of understanding the way in which court law operates in environmental context. Look, I'm just going to share the screen. Yes, Tony?
That environmental court, are they binding decisions?
Yeah, absolutely. The Planning and Environment Court operates as, if you like, a division of the District Court. So the Planning and Environment Court judges are constituted by District Court judges. Not every District Court judge sits in the P&E Court, and some sit in the P&E Court much more than they do in the criminal jurisdiction. But it is binding. But it's binding in the ordinary principles. So a decision of the P&E Court is not binding on the Supreme Court, it's not binding on the High Court, and a decision of a single judge in the P&E Court is not necessarily binding on another single judge in the P&E Court. But it works in context, so it should be highly persuasive from one court to the other. Decisions of the P&E Court are, of course, binding on the Magistrates Court and Tribunal.
Yeah, it's just a question because I was reading some case today. They were saying that guidelines, Guidelines were, you don't have to follow them, but because they're linked to legislation, you should follow. You must follow.
Yeah, I'm not quite with you. Sorry, Tony.
No, I'll get back to you on that.
Okay.
I'll write a question out and post up on Ukraine.
All right. No, that'd be great. Thank you. Appreciate that. All right. So the P&E Court has power to deal with planning appeals, and that's mostly merits review, merits appeals. So when it comes to challenging an administrative decision, I think we touched on this last week, and we'll certainly touch on this in the notes in about week 11, I think. There's a difference between a merits of review and a judicial review. Look, in essence, a judicial review is where a court is asked to consider whether the methodology used and the legal process used by an administrator was legally correct. They're not there to make the decision, but to give a ruling about the process. So, for example, if there's an allegation that a decision maker was biased or just simply didn't have power to make an administrative decision, then under judicial review, that decision can be challenged in terms of its legality. Does that make sense? Now, a merits review is different. A merits review is where the court, in this case the P&E Court, steps into the shoes of the decision maker and actually makes the decision, the correct and preferable decision. So most of the planning appeals that you see, they're all to do with merits reviews, and that's where the Planning and Environment Court substitutes its decision for the decision of the administrative person who made the decision in the first place. Now, let's talk quickly about how we get a matter to the Planning and Environment Court. And to do that, I'm going to share the screen again. And hopefully you can now see a Word document. So this is pretty simple, but X appeals to the P&E Court at, I don't know, Brisbane, against, set out the decision, and X seeks the following orders or judgment. So that's really basic sort of drafting, but that's all you need. So then you set out the orders that you need. For example, okay, you might say, I want an order that the appeal be allowed and the development application refused, or such other orders as the court considers appropriate. So that's a really basic outline of the relief sought and the orders sought. And then you have to go into the grounds of the appeal. And again, this is a really basic level. You'd probably want to put in more detail on all of this. But number one, you say the development application should be refused because it conflicts with the planning scheme and there are not sufficient grounds to justify approving the application despite the conflict. The proposed development will have an adverse effect on the environment and, etc. So as you're going through the first assignment piece, Preda-John case, have a think about what areas, what were the specific grounds that were relied upon when the matter first went to court. So, in other words, what I'm trying to express is this. As you're reading the case, think about how you would draft the application, how you would draft the appeal to the P&E court, and what grounds would you rely upon given what you know. And think about how you'd actually draft it. You see, I'm really keen for you to be good practitioners. And if next year you're practicing first year in a law firm, one of the partners comes to you and says, today we need to file an appeal in the Planning and Environment Court. We need to file an application rather in the P&E court. You've got some idea of what you need to put into the application. All right, so that's what we might put in. I'll just go back to number one. The proposed development conflicts with the planning scheme. Andrew McGoffin is going to assist us with providing some further detailed advice in relation to IDAS process. And Andrew is one of your colleagues studying this course, but he is a town planning consultant. So I'm really looking forward to getting some assistance there from Andrew, and I'll come back to some other assistance that Andrew has provided to me recently as well and acknowledge that. But anyway, the point is that one of the grounds upon which you say the development should be refused is that it's in conflict with the planning scheme. And when we talk about the planning scheme, there's a whole range of different things that we mean, but in summary, we just say the planning scheme. All right, so that's a really basic application to initiate a merits review process. Are there any questions on that? Or is that all really simple? Okay. Now, bear in mind, of course, that, yes, Tony?
How big do they have to be, the application?
You could get away. You could get away with that. You could get away with just that.
Yeah.
That would be sufficient, but probably you would generally go into much more detail than that. And now I've really mucked things up. But that's probably all you need. But you could go into 4 or 5 pages of more detail if you want.
And is there a form you use, or do you just do it on?
No, it's definitely a court form.
Okay.
Definitely a court form. I just can't remember the court form number. I'm sorry.
Oh, no, that's right.
That'd be pretty easy to do. Pretty easy to find. Would be a good exercise to find that. And if anyone wants to find the appropriate form and tell us what it is on UCRU, that would be excellent. And maybe even incorporate this sort of thing, this sort of wording into the form. What if I cut and paste that? I've got to get rid of the stop highlighting. What if I cut and paste that and I'll put it into UCRU now, and we can use that as the basis for some material. All right, so it's posted there and you know what that means. So I'll just add a bit of commentary to it. Can anyone put the following material into the appropriate court form? ? Okay, so we'll just see if anyone can find that. Thanks, Tony. Now, are there any questions about what I've said so far there, or is that all pretty straightforward? Let's move on to the next one. The other thing that you might do in the Planning and Environment Court is initiate some material in relation to an enforcement function. So what I've got on screen is in relation to Fraser Coast Regional Council and Byrne Brothers. It's an actual case. The council sought to enforce certain things pursuant to Section 601 of the SPA, and what they sought was a restraint to restrain the respondent from carrying out accessible development, and you can see the rest of the wording there, on the basis that it was inconsistent with the conditions of a development permit granted back in 2005. So that's the sort of wording that would be used in the enforcement function phase of the P&E court. So a party wishing to be heard should file an entry of appearance or notice of election to be a co-respondent to an appeal or application. Okay, look, I'm going to take the opportunity while I've got this up on screen to say, let's see if we can find some information about that case. Fraser Coast Regional Council up against Byrne Brothers from 2013. And if I'm going too fast, please let me know. But I think this is really important. And if you haven't seen this facility, I think it's very much worth having a look at. I'll get rid of Arnold. We'll go into Queensland Courts, Courts Queensland, and I'm sure you're all familiar with Courts Queensland. If you're not, you should have a look at it. For those of you studying the course in different states or territories, please feel free to have a look at your own state material for the counterpart. So I'm just going into Queensland Courts. So there's the Land Courts decisions. That's handy. But what I want to do is have a look at the civil files. So we'll go into civil files and you'll see that there's a search facility there. Have I lost anyone so far? We're all good? Okay. Now we'll do a party search. You can see that there, party search. And we have a real advantage when it comes to having a sticky beak, if I can use that term, for planning and environment court files, because we have information on the court's website for P&E matters that we simply don't have for other jurisdictions. So this is great. This is a little inside secret. Fraser Coast Regional Council. We'll do a search for that as a party. And you'll see here in bold, it comes up with various cases where the Fraser Coast Regional Council is a party or involved. Okay, so here we have Milling, Reese, Exchequer, Walter Elliott. I'm just panning down the page. Knight, Walter Elliott. And there we go, Byrne Brothers. We got to it. All right, so that's the case that I was talking about before. Now you see this little expansion button here, View File Details. If you go on that, this is really great because it will give you information about the case in detail. And I mean real detail, it's great. So here we have the events. So we've got the parties and who's representing the parties. And then we have the events, the application that was filed, and the result, an order was made, adjournment, order made. It has the name of the judges that were involved. So you've got judges Rackerman, Jones, Horniman, Wren, Everson, so a few familiar names there. And we pan down and now we've got the documents. And this is the part I really love, because if you're looking for a precedent, this is a great place to look. And if you want to know how to actually practice in planning and environment law, you know, Bates is great. It's really terrific, but it's not going to teach you about the documents you need to file. So the purpose of showing you this is to supplement the theory in Bates with some really good practical material. Okay, let's have a look at this. If you want to have a look at the originating application, you can see it right here. And this is the actual document that was filed in the P&E court that did relate to the enforcement order that was sought. So we can actually see now what the parties lodged. And that gives you a great guide as to what to file if you ever have to draft an enforcement hearing. Sorry, it's a bit slow. Document's fairly large by the look of it, although it's only 7 pages. And at this time of the evening, my internet seems to get very slow here. But hopefully you can see that now, and I'm sure it's worth the wait.
So where was that in again, John?
Yep, I'll backtrack, but this is the originating application. So the Fraser Coast Regional Council applies to the Planning and Environment Court. Oh, and there's that form number. It'll be up here somewhere. Applies to the Planning and Environment Court for an enforcement order. And I've just basically, what I showed you before was partly extracted from this material, and there it is. It's a Form 4, P&EC Form 2. Sorry, a Form 2, P&EC 2. All right, and that's the actual form. So if you want to know how to draft an originating application in the Planning and Environment Court on behalf of a council seeking to obtain an enforcement order pursuant to Section 601 of the Sustainable Planning Act, there is a sample. And you can see, as I said, Tony, there's a lot more detail on this than the brief overview that I gave you before. And this is much more what you'd expect to see. All right. So I'll just backtrack. Are there any questions while I've got that particular form up on the screen? No? All right. So I'll just get rid of that and I'll backtrack. So this is the file summary in relation to this case of Fraser Coast Regional Council and Byrne Brothers. If I go back, I think this will work. You'll see that that case is one of many cases that come up under the name search of Fraser Coast Regional Council. And if I go back one step, that's the party search page. And if I go, and I typed in Fraser Coast Regional Council and hit the search button. If you go back one more, you'll see here that you can just click the party search facility on search civil files e-courts. And if I go back one more page, we're at the landing page for Queensland courts. So how simple is that? How good is that? All right, so I'll stop the share at the moment. And I think that's a really good way to get an idea of what is actually lodged in the court, the P&E court. All right, so are there any questions from that arising? Form 2, Tony, got it? Yep. Will the example be posted on Moodle? Yes, I think I just posted one of those, but I'll post the other part as well. All right, are there any questions there? Okay, well, let's move on then in relation to what we're talking about. So I'll post some samples on Moodle. The other thing that is really important with Planning and Environment Court is that it's not just a matter of dealing with the court in a litigation sense. ADR is really important. I reckon Predajon documents are on file. That's a really good question, Michelle. I must confess, I don't think I've looked, but they might be there. That really could provide some good insight into the first assessment piece. Great thinking. ADR is important because the ADR service in the Planning and Environment Court jurisdiction is very sophisticated, and quoting from the District Court of Queensland annual report of 2011, it says the court's ADR service has been recognised internationally as providing visionary ADR access to justice. So you might want to think about looking at that ADR provision, and Peter Stilgo set that up. Peter is now senior member at QCAT. All right, look, I'll keep moving on. If there's any questions, comments, please let me know. Feel free to interrupt. The courts, I think I've listed this somewhere in the material. Land court deals with mining litigation, and you'll see the members that are in that land court. I think there's 4 members in Queensland for the land court. Magistrates Court and District Court has jurisdiction to deal with criminal prosecutions. The Building and Development Dispute Resolution Committee, that deals with whole wide range of disputes in relation to development applications of a particular type. It might be dealing with administrative issues primarily, or building matters, decisions about swimming pool fencing, kind of at a lower level, if you like, appeals against compliance assessment, or appeals by agency, advice agencies. So I won't go into any more detail of that, but, appeals against plumbing and drainage certificates and those sorts of things. There's a whole range of things that might apply. Infrastructure charges that are imposed under the Sustainable Planning Act, etc. You'd expect those things to go into the Building and Development Dispute Resolution Committee. Okay. All right. And the reason I'm saying this is that sometimes you have to be careful to ensure that you check the legislation to go to the right place. What happens if you file an application in the, let's say, the Building and Development Dispute Resolution Committee, and it's wrong? Can you think of some of the issues that may occur why your client may be dissatisfied with your services? You can use the chat facility. So why is it important to get it right and go to the correct venue for litigation? I'm sure we'll get an answer or two through. What was that? Sorry, Cheryl?
If you don't go to the right place, it's going to cost you a lot of money because you'll be kicked out and told to go to the right place. Yes,
timeliness as well has been added. Exactly, there is that issue. It could get thrown out before it starts. And it may be rejected, but it may not be initially rejected by the administrative staff. It may only be rejected once it goes through the first mentioned stage. Another issue is costs. The court or tribunal may say you've come to the wrong jurisdiction. The other party may say we've been forced to come here. We should never have come here in the first place. So we want our costs, and the cost might be on an indemnity basis, meaning it's more than just the actual party and party cost, but the whole thing. And a really nasty consequence may be that because you're on such tight time limits when it comes to lodging appeals in the Planning and Environment Court, if you miss a time limit, your client's claim may be lost. And you're just not going to, I don't know how you recover from that sort of stuff. So that's a really difficult issue. So thanks for that contribution. When you're considering litigation, in addition to getting the forms right and looking at the legislation, do have a look at the rules. The Planning and Environment Court has its own rules, 2010. So look at those specific rules for the P&E Court. And of course, there's the standard Uniform Civil Procedure rules that apply as the default provision. So if anything is not contained in the P&E Court rules, then look to the UCPR, and that's where the material will be. Okay, let's move on. I know I've been talking for a lot and we're sort of running out of time, but I've got a few more things that I do want to tell you and show you. So let's have a look. If I can remind myself what that is. Oh yes, we want to talk about the problems 2 and 3, which were allocated to you. That's one thing. And oh yes, very importantly, I want to let you know about sorry, I'm just looking to see where I put this material that I've saved ready for this lecture. Here it is. Okay, I'm going to share the screen again and thank and acknowledge the contribution from Andrew McGoffin. Andrew is one of your colleagues doing this course. He very carefully read the second week's material and said very nicely and respectfully that I got a couple of things wrong. So I want to alert you to what I did get wrong and how it's been changed. So that's the material for week 2. You may have read that, I'm not sure. But on page 13, and I've highlighted it there, hopefully you can see it. When talking about impact assessable development or code assessable development, we're really talking about the category of assessable development. and I wrote down self-assessable development. So I've taken out the word self. So I've taken out the self-assessable, and I've replaced it with assessable development. So watch out for that change. If you've already downloaded your notes, on page 13 there will be that alteration. On page 19, I made a note here that you can obtain compensation in relation to a certain number of things, in particular section 704 and 705 of the SPA. And then later I wrote compensation is not claimable where a planning scheme changes. So that is inconsistent with what I'd written here in 704, 705. So the actual correct answer is that qualified by section 704 and 705, then the position is that you can't obtain compensation where a planning scheme changes. So I've added in the highlighted bits regarding the qualifications in that regard. And the third change is in relation to question number 2, where I'd put in relation to what type of development is a merits appeal available. What I should have said is a merits appeal available to submitters, and that is only in relation to impact assessable development. If I leave that out, as far as developers are concerned, they can apply for a merits appeal in relation to any development which is rejected. So if you're acting for a submitter, that is like an objector, if you like, the merits appeal is available only if the particular development in question is impact assessable development. Now, I know that's moving pretty quickly, and don't worry, just let some of these terms gloss over you a little bit. It'll all come together a bit more when we talk about IDAS, which I think is in week 5, and I think Andrew McGoffin is going to assist in that regard. Speaking of guest speakers, I'm very pleased to say that we have a couple of guest speakers lined up. One of those will be Phil Jeston, is coming back for another session, and we have, and I'll just stop the share now. We have Sean Ryan from the Environmental Defenders Office is also going to provide a presentation in relation to, I think, the problems associated with being a community litigant in terms of environmental law appeals, and that should be hopefully in a few weeks' time. Thank you very much to Lee Chevelle for making that initial contact. And I would urge you to have a look at the Zoom video that was provided by Roger Curry, which is uploaded to your material, and that is excellent commentary in relation to the difficulties facing community litigants as well. So at this stage, the dates are tentative for those particular speakers, but I'll see if I can identify better where it's likely they will come in and provide their guest spots. From memory, I've got Andrew coming in for week 6, which will be, that's a problem, week 6, isn't it? Week 6 commences on the 21st of December. So we'll have to have a look at that. I'm not going to get anyone here on Christmas Eve. I know that. So we'll look at a special day for that one. Week 7, that comes in a few weeks later, the environmental impact assessment. That will be for Phil Jeston to do an update in relation to an earlier Zoom session that he gave. And I think from memory, I've invited Sean to come in and speak to us pretty soon. It might even be next week. So I'll just, as we're speaking, I'll see if I can find that that date that I've invited him to come and join us. Oh no, sorry, the 10th of December, I've invited Sean to join us. So that's all tentative at this stage. All right, now what else do I want to show you or talk about? We're getting close. And thank you for your patience. You've been very patient with me as we cover a fair amount of material. Look, I think the last thing that I want to do is just talk about the second of the problems for week 2, which is problems 2 and 3. That relates to the relevance of common law in environmental protection. And there's a couple of different questions that really tease out the same sort of answers. I must confess I haven't looked on Moodle yet. I'll have a quick look. Has anyone answered those questions? Has anyone provided some contribution to questions 2 and 3? And if so, if you wish to talk to your contribution, now would be an excellent time to do that. I've got a nope coming through. We'll have a look. Problem 2, we'll see who's provided a response. I don't see anything there. Tony, have you provided something? No. I can't see any answers to problem number 2.
No, I read them. I didn't put anything down on paper yet.
No, you're right. Okay. Problem 3, we probably haven't got any contribution there either if we don't have any contribution for problem 2. All right, well, we probably need to do a little bit better than that. I appreciate that there's a lot of reading and a lot of work, and I don't want to bog you down, but I'll just give a brief overview of how I see it. And this is really a combined comment in relation to both problems 2 and 3. Of course, we have the separation of powers. We know that from introduction to law, legislation, executive, and judiciary. If we had all of them in the one, we'd have a dictatorship, and we don't want that. So in terms of our democracy, some of the things that are important, which are protected to a degree by judicial review, isn't problem 2 and 3 in week 3. Sorry, Tony, am I getting ahead of myself? Because that would be great. Week 3, yes. All right. Let's go back to problem 1. Thank you very much. I'm ahead of myself. No wonder there's no answers. We don't have any answers to problem number 1 either. So that's not very good. All right, so the overview of the structure of legislative, executive and judicial branches, state and federal, in the making, implementation and interpretation of environmental law. Look, we've covered some of that already. We have that separation of powers, the dictatorship if we don't. We have the role of the courts in terms of judicial review. We have the hierarchy. Commonwealth sits above state. Legislation sits above common law. We know all about that. There is the issue of acquisition of property on just terms. That comes into play as well. So there's a few issues there. I won't say any more than that, but if you do wish to provide an answer, then please do so. So just so you know, all of the discussion is really on you, crew, with the exception of these weekly problems, which is where you might put a response in Moodle. Okay, let's see. Have we got any further comments? The presentations that I've mentioned, they will be part of our usual sessions. Okay, well, thank you very much. I'm just about ready to stop the recording. Before I do, are there any questions or comments? Okay, well, all the best. Thank you very much for your patience in listening to this session, and we'll see you next week.